Good. This is a time set for oral argument in our case number CV 220160, Goodwin versus Goodwin. Good morning, counsel. Each side is allocated 20 minutes for oral argument. We have an appeal and then a cross appeal. So appellant, you each get 20 minutes. Whether you wish to reserve a portion of your time for rebuttal on your appeal is up to you. You'll need to keep track your own time at the podium clock. And for the cross appeal, those same rules apply. We have reviewed the record. We've conferenced the case. We're familiar with the matter. We'd encourage you to keep that in mind as you present oral argument today. And please, when you begin your presentation, tell us your name and the party that you represent. Mr. Cook.
Thank you, Your Honor, and thank you very much for your courtesy to my client and to me. My name is Alan Cook. I represent the wife in this matter, who is the appellant on appeal, Mrs. Goodwin. And I would have to ask the court to reserve 5 minutes. Let's let the court know that I want to do that before you get into questions, whatever questions you may have. I would ask the court to consider the fact that opposing party did not file a countervailing statement of facts in this case, and so the statement of facts as set out in the opening brief, I think, are the appropriate facts. Some of these issues are minor issues, but since we're here, might as well fix them in any event. But the two principal issues in this case are the ones involving the 529 account that the parties had for education for the children, and the issue about husband's 401k. The 529 account had well over $100,000 in it, and the parties at one time agreed that they would have joint management of the account, and the court didn't do that, either of those things. It awarded the account to husband in full and put strictures on it that I don't think the court has any jurisdiction.
Well, because I am sure read the record that way. I thought husband and father just was able to control the account and manage it. I wasn't aware that it was awarded to him.
Well, Your Honor, the account is only in his name.
But it's for the benefit of his children.
Well, the problem with that, Your Honor, is that these things are statements of intention, and the fact is the money belongs to the parties. The money is not an outright gift to the children. It was never gifted to the children. This is a tax scheme set up pursuant to the Internal Revenue Code under Section 529 of the Code, and the only cases I've seen that talk about this say it's the property of the parties and it should be awarded to the parties. And if it was awarded to the parties jointly, that would be okay. And if it's awarded half to each party, that would be okay. Or because everything is in husband's name, if it's going to stay in his name, then wife's entitled to offsetting property plus interest at the legal rate from whatever date it was that the property was transferred to him. The decree says that husband was going to sole management over the 529 accounts. He was also ordered to manage the accounts solely for the benefit of the children, receiving a personal benefit from the accounts, and providing an accounting to the wife. Under those circumstances, I'm not sure that husband, father can take the money and run if that's a concern. Well, Your Honor, divorce is a creature of statute, and there's nothing in the code, dissolution code in the state of Arizona, anywhere in Title 25, that says that the Superior Court has the authority to tell people what to do with their property. They can't do that. They can divide it as between themselves. The court can make awards of property, but it can't tell them what to do with it once it's awarded to them, unless it's security for something else. So
well, if husband, father acted inappropriately in violation of the decree, I'm sure that your client could come to court to try to enforce the decree. I don't know how that would resolve itself, but your client could certainly do that if there were any shenanigans going on in the future.
Your Honor, no part of this asset was awarded to my client. She's entitled to her half of this asset. and the court can't tell people what to do about it, and it doesn't make any difference who's managing it. It could be Mr. Goldman Sachs himself, and it doesn't make any difference who's managing the account. She has a right to her half interest in this account because it's not a gift to anybody. It's property accumulated by the parties that's in his name only, like almost everything else they owned, in his name only. And my wife is entitled to her one half. And the fact that the court says he has to manage it for the benefit of the children treats it as though it's the children's property, and it's not the children's property. It's not their property until it's given to them by the parents. And so all this is a case where the judge is doing something because he might think that husband would manage it better, but that's irrelevant. Wife's entitled to her half, Your Honor. That's their argument. They haven't cited any law to say that the court has authority to order the parties to manage this account in any particular way. And the fact that the court only said that he had to tell wife what he was doing is different. What if the children die 3 years from now? It's in his name. And then wife says, where's my half? And he says, well, it's awarded to me. It's in my name. That's what the judgment says, and you didn't appeal.
Counsel.
Yes, Your Honor.
What are you saying the decree should have said then with respect to the 529?
I think it should have awarded either the account to the parties jointly to decide what to do with it down the road, with her name on the account so the husband didn't have the right to take it himself. Or, I think the better thing to do is award half to each party and let them manage their account any way they want to. But the fact of the matter is, it's their property. It's not a completed gift.
Can they withdraw personally from the 529?
Yes.
Help me understand that.
They can liquidate the account if they want to.
Okay, without any tax consequences,
Well, there
any
may be.
issue with respect to the decree?
There may be tax consequences because my understanding is these things grow tax-free. And so there
Right.
may very well be tax consequences with respect to the growth in the account. But that's a different issue, and that has nothing to do with the fact that the parties own it. It doesn't belong to the children, and the court doesn't have a right to tell them how to save or manage their money. I think it's that simple. And
So the court could have liquidated it, could have said, yeah, you need to sell these assets.
well, in theory, you could say that, but they're already liquid assets. They're investment assets, and you
I
can award
understand
half to
that.
each party.
But your point is how they're held.
Well, I think if the parties didn't want to liquidate them, I don't think the court should tell them they have to liquidate something they don't want to liquidate.
Well, that happens all the time with real property.
Well, I understand that people do those things, Your Honor, but the fact of the matter is, you're talking about when you do something like a quadro or domestic relations order to divide a 401k plan, there's a process for doing that, and that includes making a transfer from one spouse to the other. But it doesn't have to be done in cash. It could be done in kind. That's not impermissible. And this would be the same thing. It costs money when you sell assets like this.
I understand that, but if I hear you right, if the court had ordered liquidation of this, you would have no objection to that.
Well, as long as my client gets her half. I think it would be too bad if it wasted money, but I think my client's entitled to her half, and if it has to be liquidated to do that, then that's what can happen. And then she can provide for the education of her children as she sees fit. So the next issue is the one about the husband's 401k. So when these parties went to trial, husband said that he didn't have 10.75 years of his 401k record during the marriage. And nobody knows what happened in that account during the marriage because there are no records. And I cited you the case that says that when evidence is exclusively within the province of one party, they have the burden to come forward with the evidence. And here, what husband did was he hired an expert to say, this money would have grown to X based upon all these financial things.
Well, because of that seems to be a factual determination of credibility, and our standard of review on that would be pretty difficult for you to make. We totally don't make credibility determinations. The trial judge does that.
Well, the problem, Your Honor, is that the standard for division of this for proof for husband is by clear and convincing or clear and satisfactory evidence. It's not a preponderance of the evidence. And if it was preponderance of the evidence, I don't know that we'd be here on this issue. But the problem is you have an asset that the expert said existed at a point in time, and it's an asset that's a marketable security, mutual funds, and there's prices for those securities that are posted, And if they had the securities when the parties were married, and he still has the securities 15 years later or whatever, and there's a marketable price for those securities, seems to me you'd multiply the shares times the price, and that would be the value.
But again, whatever the standard of proof is for the trial judge to make those credibility determinations, determine what the facts are, not us.
Well, Your Honor, there's a reasonableness requirement that's read into these rules of construction, and there are numerous cases where courts make findings about the fact is you don't have clear and convincing evidence. This is a case where the evidence was within husband's control, and he didn't have it to offer to the court, and because of that, wife had no way to critique what was said by the opposing expert or by husband. Now, I think it's important in this case, and maybe the court won't, but I think it's important, that when both of these witnesses, both Mr. Gorman and husband, were asked by husband's counsel in court, and I've cited you to that language and quoted the language, and did you look at all these other records? They both said yes, in knee-jerk fashion perhaps, but they both said they had looked at records that had never actually been produced, and that was part of the support for Mr. Gorman's decision. That's what he said in his testimony. And he never said otherwise in court. And so the fact of the matter is you have evidence where husband hasn't produced the records and thereby wife has no way to refute what he says. The evidence is entirely within his control because they were his records. And Mr. Gorman's come up with a calculation of what these things would have been worth if X, Y, and Z had happened or whatever. It's a fantasy number, is what it is.
Well, so your argument is that given the record, there is no way as a matter of law the trial judge could have determined the credibility of the witnesses in the way that he did.
Well, I think it doesn't make any sense to say that Mr. Gorman's credible about this when his testimony is demonstrably false, as indicated in the record. How can you say that he's being accurate about anything? But more than that, I think it's also an issue of clear and convincing evidence, Your Honor.
Counsel, help me better understand that point.
Sure.
Because if I heard you right a bit ago, you said, hey, if it was preponderance, we wouldn't even be here. There's nothing to see.
Maybe not, Your Honor.
Fair. That's fair. That's fair. That's fair.
That's a hard standard to get over.
But why, yeah, that's fair. But why, with that sort of heightened standard of proof, how does that alter the analysis about, tip it from maybe nothing to see to reversible error, given that the same issues you're talking about would have been present with preponderance as opposed to clear and convincing?
They're not the same, Your Honor. Number one, if my client comes to me and says, I got screwed on this issue, whatever, I'm entitled to half of this, nobody should believe Gorman, what I would say to him, here's what the standard of proof is, and you could win or lose in the Court of Appeals. But when the evidentiary standard approaches beyond a reasonable doubt, and I think that's what clear and convincing means.
It's somewhere in between, for sure.
It's a very high standard.
It's higher than preponderance, lower than beyond reasonable
and I
doubt.
would say it's unfortunate that we don't have case law to say how high that is. But to me, when you're talking about property issues like this, where you have statutory rules about division of sole and separate versus joint property, you got a pretty high standard to show that this is sole and separate property of husband. And when he hasn't produced the records, and the cases indicate that's his burden under facts like this, and when his lawyer, both the lawyer and the husband testified, not the lawyer, but the husband and the expert both testified falsely on direct from the...
Well, you say that it's false, but the court evidently didn't believe it was false. So your argument would be correct if we knew the testimony was false, but we don't know that. And that's not our role here today to make that determination.
Judge, it's in the record. It is in the record. And if the court ignored it, ignoring it is different than it not being in the record. And the fact is, it's in the record. And counsel apologized for asking a question that didn't have a foundation, that was in fact a false premise, and both her client and Mr. Gorman agreed with what she asked, and this is the problem you always have when you have leading questions that are permitted by the court. as is often the case in family law cases, because of the crush of business that they have. And I understand that happens, but the fact of the matter is you're talking about an expert witness, and she could have said, what records did you consider? And he could have looked at his file to see what records he had. But she didn't do that. She talked about all the records subpoenaed by wife, none of which covered this period of time. The records that were subpoenaed by wife only affected year 2018 and subsequent. It didn't include this almost 11-year period for which there were no records at all. And so from my client's standpoint, and my standpoint, when I look at this, his burden is high. And he hasn't even come close to meeting it because A, he doesn't have the records, and B, what you do have in the record is you do have the number of these shares that existed at the time of the marriage, and you have the price of those shares as of the date of 2014, whenever they were transferred to Wells Fargo. And so you can calculate the value.
And counsel, let
Yes,
me
Your Honor.
make sure I understand it. Time's going fast.
Sure.
Your argument is not that he wasn't entitled to those shares, it's that the valuation affiliated with those shares was incorrect.
Yes, it's off by about $20,000 as of 2014, and my client graciously, I think, agreed. She doesn't object to him having those shares or whatever, but she disagrees with inflating them to something else because of what might have happened, but we don't know did happen. We have no way to know what happened, other than the fact we do still know the value of the shares. It's just like a car, Your Honor. You buy a car, you put a bunch of money into it, and later on some expert says, well, that car is worth $50,000 because that's how much you spent on it. But the fact of the matter is, there's a market value for the car, just like there is for these stocks.
See, the cars I drive decrease in value, they don't increase in
I
value.
understand, Your Honor. And the fact of the matter is, we do have a market value for these stocks, and there's no good reason to deviate from multiplying the number of shares times the market value to come up with a value. I also have asked that my client be awarded her fees and costs based upon the gross disparity in income here, and also because of reasonableness. And there are some other issues here, but I think that those are more straightforward. And if I may, I'd like to save my time.
Very well.
Thank you, Your
Thank
Honor.
you. Ms. Henderson.
Good morning, Your Honors, and may it please the Court, Mary Catherine Boyd for Henderson for...
I apologize, I've been using a different term all morning. And
I have a firm rule that I will answer to either name. If I can't decide what I can call myself, I'm not going to criticize anyone else for it. I do, Your Honors, agree that certainly the biggest issues before the Court are the 401k and the 529 educational funds.
Can you talk about what the rules are regarding what the court can order in the decree regarding the 529 account?
Judge, I would suggest that, but for the fact that there was an agreement on several of these issues, there's an argument that the court might have erred in holding, especially under more recent case law, in holding the value of those accounts separately and not attributing a value to husband for receiving the assets. However, the record is pretty clear that the parties did agree to that. Both parties' pretrial statements and calculations of the division of property include no value to either party for those 529 funds. In the pretrial statement of husband represented an actual agreement between the parties, which was our understanding, that the funds would be managed for the benefit of the children, that neither party would receive any benefit whatsoever from the funds, and that they would not be included in the division of property.
What would be the consequence of your client violating that agreement?
The only argument that the only issue with regard to those funds the parties did not agree on was management. And at no point did wife contradict the statement of agreement that was made in the pretrial statement of husband. And at no point did she indicate that her valuation position was contingent on being awarded a joint management.
My question is, if your client decided to liquidate the 529 account or do something with the assets that did not accord with the agreement between the parties, what would the consequence be?
Well, given the language of the decree, were my client to mismanage the funds or receive a personal benefit in any way from the funds, then he would be in violation of the decree, and he could be held responsible for the violation of the decree, and arguably required to make either wife or the children whole, depending on the circumstances.
He could be held in contempt.
He
too,
could be
couldn't
held in contempt.
Let me ask the opposite side of that question. What happens if all those funds aren't used? The children go to college and they're delightfully encumbered with scholarships and other things, and when that effort is done, under the current decree, there's still money in the 529. What happens?
Well, what we know from the decree is that husband cannot receive a benefit
Right.
from those funds, so, and that they are to be managed for the benefit of the children. So in order to comply with the decree, my advice to him, if he were to come to me in that situation, would be to liquidate the remaining funds and give them to the children.
Is that permissible under whatever the rules for 529 accounts
I
are?
believe it would be, depending on the age of the children at the time and some other factors. I know there are procedures for withdrawing those funds when they're not used. So I believe that would be the case.
For a 529 account, is it specifically devoted to specific beneficiaries, or is it just in the name of the account holder?
My understanding is that this account is in the name of the account holder, and that he is bound then by the language of the decree with regard to management of it. But there are tax deductibility issues that relate to the tax funds that are contributed to the account are tax deductible based on their being segregated for
Right, but
education
what
purposes.
I'm getting at is, say father had other children. Conceivably, again, it would be in violation of the decree, but he could use those funds for other children, not the children of this marriage, correct?
Theoretically, I would think that would be, that's certainly a possibility, but as you say, it would be in violation of the decree. With regard, if it please the court, I would switch to the 401k for just a minute. One of the things that Mr. Cook said repeatedly was that the records that were missing were within the providence of the husband. The record does not support that. Husband testified in relative detail to the port, and I cited these portions of the record in my brief, that in fact he could not obtain the records that were missing. That because of the movement of the account from one administrator to another, those records were no longer available. And so it is not something that these were records that he had. Theoretically, he would have been sent statements, but he testified that those statements had been shredded years and years ago. And this is, in my brief, I cited the Chauncey case, which is a memorandum decision, but I think is relatively persuasive on the issue. In that situation, there was a much more complex tracing than the one that we have at issue. The separate property in that case was an inheritance that had been received by husband. This was a much longer marriage than the marriage that we're dealing with, and the transactions that husband in the Chauncey case engaged in were over a greater period of time through a variety of different assets. So, and the court, I think in that case, rightly concluded that where there is a valuation and a tracing based on standard accounting principles that can bridge the gap persuasively, then you don't have to have every statement from the account going back to the beginning of time. What Mr. Cook's rule would really suggest is a beyond a reasonable doubt standard of proof. In other words, if we had every statement from the account for the entire duration of the marriage, we would not have necessarily needed an expert to make the trace or to bridge the gap. We would have all of the evidence. It would be clear.
But Counsel, Mr. Cook says that everyone should know that the testimony was false. I'm intrigued by that.
Okay, so the quote unquote false testimony that was given is in a response to a question with regard to a subpoena that was issued by wife for certain records. Everyone in the courtroom at the time, with the exception of wife's then counsel, was under the same impression that the records had been subpoenaed for the duration of the marriage from husband's employer. And I include in that wife, who also testified that the subpoena had gone back to the beginning of time, beginning of the marriage, when she issued it to husband's employer. And the only purpose of that testimony was to respond to some arguments that were being made on cross-examination by wife's counsel, and the claim that sort of there was some withdrawal from the funds, contrary to husband's testimony. And the point that was being made by Mr. Gorman and myself in asking the question was just that if there was some evidence of a withdrawal, you would have likely seen it in husband's employment records. These were records that were not relied upon or referenced in Mr. Gorman's report at all. He doesn't make any mention of the subpoena or any records from the subpoena in his analysis. His analysis is clear that he assumed that the husband's testimony was truthful and that there had not been any transfers within the accounts or withdrawals from the accounts other than when they changed plan administrators. Certainly mistakes happen occasionally in trial. This was one that did happen, and it was corrected before the end of trial, as cited in my brief. The opposing counsel mentioned the issue again. I was able to look up the subpoena and conceded that, in fact, it did not cover the time period at issue. Wife raised that issue again in her motion for new trial, and made again the argument that, in fact, that this quote-unquote false testimony had some bearing on the quality of the analysis, and the court rejected that argument, the trial court.
So the trial court accounted for the evidence and the extent of its falsity.
I believe so. I believe the records reflects that, Judge, and that's our position. I would note that wife's position with regard to the account was different at trial than it is after trial. At trial, she took the position in her pretrial statement that husband should receive the value of his pre-marital contributions together with some sort of interest. And it wasn't very specific as what the interest would be, presumably the legal rate of interest. And then only after trial did she change her position to this new valuation that's put forward today, where we take the value of the stock on the market today and multiply it by the number of shares husband purchased before the marriage, which of course it clearly excludes a number of separate a great deal of property that would be husband's separate property. Husband is entitled to the passive gains associated with his premarital assets, and wife's suggested valuation excludes any dividends, any stock splits, any other activity other than an increase or decrease in what one can buy a share of stock for on the open market. And that would be, I believe, improper.
Counsel, let me ask, you could value the stock that way, couldn't you? I mean, you could determine what dividends were declared by the holdings and if there were stock splits.
And Mr. Gorman did that analysis as part of his report. That was one of the arguments raised by wife's counsel in post-trial issues, and I believe again on appeal, was that he did not rely on proper evidence in creating those calculations because he relied on material available on the internet. And that issue is addressed in my brief as well.
And you don't dispute that the burden is on your client to show the value and that it's by clear and convincing evidence? I
do not dispute either of those points. We just believe that we, as the trial court concluded, met that burden. And I would reserve the remaining time for any further comment.
Very well.
Thank you.
Mr. Cook, rebuttal on the appeal.
What counsel just said about this thing about responding on cross-examination is absolutely false. It may be that she did, but I cited in page 17 and 18 of my brief the colloquy between counsel and Mr. Gorman on direct examination, in which she asked a question. I'm looking at page 17 of my brief, and she asks, and was there any evidence contained in those documents that husband had instructed that any of his investments be moved to different accounts between 2003 and 2014? And Mr. Gorman said, no, it actually supported my analysis further because the instructions were provided that makes the investments into those original 6 funds. So that's what he said on direct, not on cross-examination. He just outright said something that was plainly false. And so when it comes time to look at whether or not we have an accurate assessment, we don't. And we have counsel talking to you about things that aren't part of the record here, at least not part of any record that I saw, about any testimony about stock splits and dividends or anything else that wouldn't be bound up in these share prices. We don't know. We don't know. These are mutual funds. And what we do know, the only thing that we know is how many shares he had, because miraculously he saved those records, even though he lost the next 11 years of records before the funds were transferred. And so the question is, how much were the shares worth at the time? And we can calculate that because, as I say in my opening argument, Mr. Gorman provided that information in his own report about what the values were. And I'd submit to you that you can't have an expert testifying falsely, plainly testifying falsely about what he relied upon, what he did, and how things supported things, and then come back and say that he's somehow more credible about anything, and that there's some reason other than just the plain value of the stock to use. It's not fair to wife to have this happen. It's patently unfair, and I submit whatever the standard is for clear and convincing evidence, that doesn't meet it. And I'd like to save my time for any rebuttal on the cross appeal.
Fair enough.
Unless there are questions for the court.
And actually, I think this is your last time at the podium.
Well, then, she didn't argue anything about her cross appeal, so does she get to then argue that now and I don't get to respond?
That she gets the last word on the cross appeal, yes, sir.
Okay, well then I would just say this about that issue. It was husband that introduced the testimony about the Jeep and whether it was or wasn't a gift to wife, and wife testified about it, and the court made a specific finding that that was wife's sole and separate property. I think it's worthy to point out here, other than perhaps the house, this is the only piece of property that's actually in wife's name. All the other assets, to my recollection, were in husband's name. Everything was in his name. This was in wife's name, and I think that may have impacted the judge's decision, but the fact of the matter is, I think if the judge's findings are to be considered, that the evidence sustains his ruling irrespective of anything else. If husband's going to introduce an issue at trial and wife is going to respond and the judge is going to make a ruling, I don't think husband should have a complaint. Thank you, Your Honor.
Very well. Thank you. Rebuttal on the cross appeal.
Thank you, Your Honors. I'm a bit puzzled at the idea that about the statement that husband introduced the issue. As noted in the brief, there are various discovery requirements associated with positions on division of community property that are required to be exchanged between the parties. Some of those are specific to Yuma local rules. One of those is the preparation of what are jointly prepared property and debt lists. Under the rule, the petitioner typically prepares the first version of the list, which husband did. It is then sent to the respondent to comment or make any changes or notations that vary from the positions taken by the petitioner and then returned for final comments. At all points prior to 2 days before trial, wife represented the Jeep as community property. She included it on her community property. Husband included it on the community property list. Wife made no contrary notation on that list when it was returned back. On wife's preparation of her own separate property list, wife did not list the Jeep. So at all times prior to the filing of the pretrial statement 2 judicial days prior to trial, it was understood that that asset was agreed as a community property asset. Wife's evidence to the contrary was testimony that it was purchased as a gift for her graduation at a date and time that was nowhere near her graduation, and that it was titled in her name because husband intended that to be a gift. wife's testimony about husband's intention was contradicted by husband, who testified that in fact it was placed in her name because she asked for it to be placed in her name, and that he specifically at the time said it didn't matter either way, that this was a community, it belonged to both of them and it belonged to the family, it was a community asset. The court did not initially specifically find that it was a separate property asset. The court made contrary findings when it issued its initial findings and orders, in one place saying that it was a separate property asset, in another location including the value as attributed to wife in the division of community property. That issue was clarified post-trial and post those findings in the arguments concerning the form of the decree that was submitted. So we do not believe that that met a clear and convincing standard of proof, and we believe that that there was not sufficient evidence to sustain the finding that wife had rebutted the presumption that that asset was an asset of the community. I have nothing further. Thank you.
Thank you, Counsel. Counsel, we appreciate your arguments. We appreciate your written briefs as well. We'll take the matter under advisement. We'll issue a written ruling in due course. Please drive safely as you head home. We will take a recess while we set up the courtroom for our next court hearing, but we'll stay on the bench when we do so. Thank you.